Well, good afternoon and good morning, everyone, and welcome to Thrive, a monthly webinar series brought to you by ARCpoint Labs, your single source employer solutions provider, helping business leaders create compliant, safe, and healthy workplaces that thrive. Today's topic, designing compliant, defensible drug screening programs for today's workforce. My name is Ryan West, your host and Thrive specialist, and honored to share the virtual floor once again with our partners at DSCI, Drug Screening Compliance Institute, Nick Hartman and attorney Bill Judge. Before Nick and Bill take the virtual stage, a few important announcements. First, ARCpoint's Thrive webinar series, held the third Thursday of every month. They're free, accredited, and you can register for our Q2 series lineup today. So that's April, May, and June webinars. Our Q2 series, which we're very excited about, is entitled Reducing Legal Risk in the Workplace. It's a three-part series that consists of different but related topics, all presented by attorneys. Today's topic is grounded in a variety of ARCpoint solutions, most notably drug and alcohol policy development and review, and drug and alcohol testing, DOT and non-DOT. Next month, published author and attorney Tom Cope is going to help us shift gears and ground his topic in ARCpoint's background screening solutions. Tom will be drawing on over 50 years of practice as a labor and employment attorney and talk about the real legal lessons he's personally experienced involving recruiting, hiring, and performance appraisals. So stories and lessons drawn from the front end of the employment life cycle. You're not going to want to miss it. The registration link for April's webinar is now in the chat. You can also register for the May and June Thrive webinars that continue the Reducing Legal Risk in the Workplace series. Second, each Thriving Thursday webinar features a new speaker and or new topic that is one, aligned with ARCpoint's suite of employer solutions, and two, aligned with your voice, content or speakers that you have requested for this monthly series. Nick and Bill are back with us today because you wanted them to present again. And of course, because they graciously agreed to do so. So keep sharing your voice. Once today's webinar concludes, there will be a survey. It's quick, it's easy, and it gives your voice an anonymous platform to consume the type of content that you want. Let ARCpoint be not just your single source service provider, but also a key education provider for you as well. And lastly, I want to quickly address the frequently asked questions that we get at the beginning and end of our Thrive webinars, such as, is this training being recorded? How do I access the recording? Will I receive a copy of the slide deck? Are CEs offered? How will I get them? When will I get my certificate of attendance? Answers to those questions are now in the chat. So go to the chat, review that info. Also say hello. Let us know where you're logging in from. If you have questions for our presenters, please use the Q&A function. They will be monitoring the Q&A for questions. And then please use the chat for everything else, sharing general comments, stories related to today's topic, and of course, saying hello. It is now my pleasure to introduce our March Thrive speakers, Nick Hartman and attorney Bill Judge. Nick is DSCI's managing partner and senior consultant, who over the past 2 decades has helped design and manage drug-free workplace programs for literally thousands of employers, both here in the US and internationally. Bill is the senior research attorney and co-founder of DSCI, with nearly 40 years of experience working on the front lines of drug and alcohol testing law in the US. To those who have yet to hear Nick and Bill present, they are a dynamic duo that possess a wealth of knowledge on today's topic, and if I might add, a keen sense of humor. So engage with them, ask questions, learn as much as you can about today's topic from these industry experts. With that, welcome back, gentlemen. Thank you so much for being here. The floor is yours.
Thank you.
Appreciate it very much, Ryan. Thanks for having us back.
Thanks to the ARCpoint Labs family for hosting today's conversation, and thanks for everybody chiming in, for joining us and for chiming in on the chat. Seeing hellos from all over the U.S., which is great. Uh, as Ryan mentioned, my name is Nick Hartman, and joining me is my partner Bill Judge. While Bill is an attorney, it's important to note the quick legal slide here that we are not a law firm. Everything that we're going to talk about today is really legal and compliant, but again, should not be construed as legal advice. As you can understand, everyone's situation is uniquely different, and therefore, we certainly recommend you take action to work with a subject matter expert or legal expert prior to taking any adverse employment action based on the topics we're going to chat about today. A great topic, got a kind of an aggressive agenda on tap for you. Hopefully, we'll leave you with a toolbox full of tips on how your workplace drug and alcohol screening program can be both compliant and, most importantly, defensible. You don't want to go out spending all this money on drug testing if you can't, therefore, defend any adverse employment action that you take based off of that program. So it's important to have it correct. We're going to talk a little bit about what the law is, talking about mandatory laws and voluntary opportunities that are there for employers that conduct workplace drug and alcohol testing. We're going to focus a lot on your policy, talking about different strategies, some guidance and considerations for whether you're crafting or going back and reviewing your policy. We're going to talk about the importance of procedures and job descriptions as well, and then leave you with some takeaways, kind of recapping our conversation. As Ryan mentioned, we are going to have some Q&A later, but feel free to utilize that Q&A box in Zoom. If you have questions, we'll take a look at those and answer those as we go throughout today's conversation. All right. So that's enough of that fun stuff. So talking about workplace drug and alcohol screening compliance. You guys as employers, you guys as service providers, you guys as DERs, designated employer representatives, have a lot to consider when you're running a compliant and defensible workplace drug screening program. You look at we call this our drug testing wheel of compliance here, but there's a web of rules, regulations, laws, and considerations that you have to incorporate into your workplace for everything that you do every day. We're going to talk a lot about state compliance. We're going to talk a bit about marijuana issues, which is the giant elephant in the room these days. We're going to talk about work comp opportunities, unemployment opportunities, mostly on the voluntary side. Talking about OSHA, some other key agency decisions, and unions and how those play a role in how your policy and program is designed. We're going to talk a bit about key court cases and also how that drives law. But what really wanted to start the conversation off of, a lot of the stuff we're talking about today is going to be in the non-regulated, the non-DOT space. We understand that you guys as employers often have federally regulated workforces as well as your non-regulated employees. And those do need to be considered a little bit differently, or I should say separately within your policy. And we'll try to paint that picture a little bit brighter for you here on the strategy on how to go about making sure that's addressed. And before I bring Bill in here, I just want to kind of get paint a picture of the law, and then we'll let the attorney school me on it. But really, the law for workplace drug and alcohol testing starts with mandatory drug testing laws. These are states that have mandatory statutes, regulations that dictate or outline the rules for which employers must follow when conducting workplace drug testing in that state or that municipality. We're going to talk about voluntary laws, which are just that. They're voluntary for employers to comply with, but oftentimes come with some very nice financial benefits for employers that follow those rules. We're going to talk about different industries that might have specific rules, like school bus drivers and such like that. We're going to talk about marijuana laws. It's definitely driving a majority of emails and phone calls into our firm about how to handle all the different laws that are coming out there and how they're more and more increasingly impacting what employers can or can't do with workplace drug and alcohol testing. We're going to talk about immunity from lawsuits. Some drug testing programs out there can provide your employer a free insurance policy from ever being sued. if you follow some rules. And then talk about some open states and how that works with following industry best practices. But a fun stat that we always like to say, there's thousands of state and municipal drug testing laws out there. And in our database, well over 25,000 court and agency decisions that drive this. And Ryan, obviously you've contested this in past that this just stuff changes so often that you must keep abreast of the different changes that are out there because they, again, more increasingly have impacted workplace drug and alcohol screening programs more than ever before. All right, Bill. So we're going to bring you in here. We're going to start with mandatory rules and voluntary opportunities. So again, and please correct me if I or added to anything that I just opened us up with, but let's start with mandatory laws.
Yeah, well, right now there are 32 states in the country that basically provide or require if you want to conduct drug testing, you can, but you must do so according to the state's rules. Now, these rules come from either statutes, regulations, or even court decisions. Okay. So, for instance, California is a mandatory state. It doesn't have any drug testing statutes except for the marijuana laws, which we'll talk about in a minute. But it's basically relying on court decisions that dictate what you can and can't do. It limits random testing, for instance, to only safety sensitive functions. So you have to make sure that you're considering not just state statutes, but rules like regulations and court decisions and how they've interpreted that. But the bottom line is in 32 states, and we have a map for you to show you what those are, based on either drug testing rules, marijuana laws, or a combination of both. You're limited to what you can and cannot do in those states' rules. So you got to be careful. Virginia, you'll see, is a different color. It's colored blue because it is the only state in the country that basically provides that employers cannot discriminate against an employee's off-duty use of CBD. The only state that has found it necessary to legislate regarding CBD.
That's very interesting, Bill, because we don't test for CBD or
We don't test for
cannabidiol
CBD. It doesn't cause a high. Yeah, all kinds of silliness. We're not quite sure why they felt it necessary to establish that law, but nonetheless, as employers, there it is.
Yeah, Virginia is a state that does have a marijuana law that authorizes low THC oil. Maybe they're trying to corroborate the two, but I think science is starting to supersede that.
Yeah.
But
so I should explain that in this map. And by the way, we have charts and maps on everything. We got more statistics than baseball, for crying out loud. But the yellow colored states are those states that have drug testing statutes that limit you in terms of when you can and can't and who you can drug test. The green states, obviously, being silly, those are the states that have marijuana laws that limit what employers can and can't do when it comes to testing. Orange states, that means that state has both drug testing laws and marijuana laws. Minnesota is a perfect example. It has long had a drug testing statute, very complicated drug testing statute, but dumped on top of that now are the marijuana laws, which limit employers in terms of how they test. So the orange states are both. Blue state, I've already talked about CBD in Virginia.
Yeah, and then the rest of the states that are gray are really where it comes down to industry best practices for conducting your workplace program. And a quick reminder here that federal laws, those employers out there that have DOT regulated employees, whether it be trucking, bus drivers, train, all the rest of the different modes of transportation, you got to understand that your drug testing policy needs to consider those federal requirements and the rules that are imposed on those employees that are conducting federally covered safety sensitive jobs. Outside of that are all your non-regulated employees, and they are thus subject to all the different state laws that we're going to be talking about now, in addition to your guys' company policy. So that'll come back up a little bit later in our presentation on how to strategy on how to address that in your policy.
Yeah, but policy's going to be our focus today, and it's important that you know all these rules so that you know how to develop your policy.
Yeah, and we put together some fun facts for you here, some eye raisers that we often utilize when we're trying to paint the picture of why this stuff's important and why the devils are in the details of those statutes and regulations. They're are some state laws that require you to have a policy, require it to be written. Some states, like Maine, require your policy to be reviewed and approved by the state's Department of Labor. So before you can even conduct workplace drug testing, there's some rules on how your policy needs to be crafted, what items need to be in there, what topics need to be covered, etc. Surprisingly, there's some states that limit or prohibit who can be tested, whether it's pre-hire, post-hire, or limiting testing to safety-sensitive employees only. There's states that limit or prohibit what substances you can test for and what cutoff levels you have to use. Oklahoma has a specific rule on limitations for schedules 1, 2, and 3 drugs and what cutoff levels you need to use there. There are states that we're going to be talking about here that are requiring employers to test for Delta 9 THC and prohibiting adverse employment action based on uh, uh, cannabis metabolites. And that's a whole new inception, which again we'll dive into in the next couple of slides here, but it's an important distinction.
Yeah, that's an evolving area of the law that you got to keep an eye on.
Yeah. Some states limit or prohibit when testing can take place, like random testing, post-accident testing. Some states prohibit the use of post-accident testing in specific situations. So it's important not to be caught on the wrong side of that. Some states limit or prohibit where testing can be conducted. Some states prohibit the use of those point of care, point of collection, or rapid instant test devices. They require lab-based testing. Those details obviously are going to matter. Some states limit or prohibit how testing is conducted, whether you're using urine, whether you're using oral fluid or hair. It may seem like you can use all those specimens in every state, but some state laws are very, very specific as to what specimens are permitted.
We've got a chart on it.
And we've got a chart on it. All these topics, you know. Surprisingly, there's some states that limit the discipline an employer can impose. Minnesota is one example that comes off the top of my head that you can't terminate someone for the first time that they test positive. You must offer them the opportunity to go seek treatment through an EAP or a substance abuse professional program, and then keep their job so they can come back. There's other states that limit discipline based off of a positive drug test for marijuana, and we'll cover some of those as well.
Mm-hmm.
There's some timing requirements. There's some notice requirements. Some states require you to use specific forms in specific instances. There's details as to who pays for the cost of drug testing, which gets kind of interesting. And then rules on how donors can dispute the test results and their rights in that respect. But again, these vary by state, so and even by municipality. So it's important to understand the rules that apply to your specific program. Okay, Bill, so we'll talk about our biggest call driver into DSCI these days is the devil's lettuce, as some people refer to it out there, marijuana. Where we stand today.
Every single day we get at least 2 or 3 calls on these issues. Now, it's interesting. Take a look at that map. It shows you that right now 39 states and 40 if you count Nebraska. Why is Nebraska singled out? Well, that's because the voters of Nebraska have approved the use of medical marijuana, but it remains in the courts, and so there's a lot still going on there before it gets kicked off there in Nebraska. Idaho, however, is the only state that doesn't have some access to marijuana, either medical or adult use. But right now, 39 states and Washington, D.C. and some territories authorize medical use of marijuana. 24 states and D.C. and other territories authorize the adult use of marijuana. And then 18 states have authorized for medical purposes CBD specifically. We do not reflect CBD that derives from hemp on this. Most states are in the process of putting those programs together if they haven't already.
And when we had this conversation 10 or 15 years ago, the stance was that these laws don't impact workplace drug testing programs at all. That has dramatically changed since, and even more so in the last 3 or 4 years, I would say. So it's important to understand that there's different limitations regarding protections for those that are authorized to use marijuana for medical reasons, And there's even limitations for those states that authorize the adult use of marijuana. And we saw also for medical cannabidiol or medical CBD. So again, it's very, very important to take a look at those statutes both at the state and municipal level to understand what the rules are that apply to your program.
As research people, it's fascinating for Nick and I to look at this and the evolution. To think that this all just started in 1996 in California and how fast it's evolved and developed. And we're now getting into some really detailed, nuancy kinds of things like, for instance, Nick and I frequently talk about the fact that we should not talk in terms of a marijuana positive anymore. We should talk in terms of what metabolite was discovered. Was it a psychoactive metabolite or a non-psychoactive metabolite? Because with states now requiring that you can only act as an employer if you find the psychoactive metabolite, this is becoming more and more important.
Yeah. It's almost like a clash of titans, Bill, where you got legalese that are happening out there, legislative action that's limiting employers, and then you have the competing science on cannabis trying to merge their way into, again, figuring out what we can or can't do. But I think the biggest thing that's important here is to understand that states are absolutely either amending or adopting rules and regulations regarding the topic of legal or medical cannabis use. And the trend that we see and have been tracking further bring more limitations to what employers can or can't do. Again, significantly impacting the who, what, when, where, why, how drug testing can take place for marijuana and what
Right.
disciplines can be imposed for those that test positive for the substance. There's state and local lawful activities law, lawful products laws that really came back from way back in the day about nicotine or tobacco use that have kind of now bled over into the states that are authorizing the legal use of marijuana. Definitely, as Bill mentioned, there are now states laws and municipal laws that are requiring employers to differentiate whether someone used cannabis recently versus past use. As you mentioned, Bill, a Delta 9 positive versus a positive for a cannabis metabolite. Where I sit here in Washington State, employers are prohibited from taking adverse employment action or in pre-hire situations unless Delta 9 was specifically found. Delta 9 THC was specifically found. You cannot take adverse employment action on a positive test for cannabis metabolites. There's safety
Yeah.
sensitive exemptions, of course, and then there's a similar law in California and Connecticut and others, typically with some safety sensitive exemptions for those employees that are safety sensitive. But again, it's important to understand that when those distinctions need to be made, so that when you have to go to make a adverse employment decision, you're not making the wrong decision.
One of the more important evolutions in this process is the fact that we now have 10 states that specifically prohibit employers from discriminating against an employee's off-duty use of a legal cannabis product. But it's not just limited to those. There are 28 states, think about it, 28 states now that basically say employers can only take action if they find that an employee has used or is under the influence at work. All right, this raises a whole bunch of issues like, okay, how do I prove it? All right. That then dictates you take a hard look at the test methodologies that you're using, urine versus oral fluid, and so on. So you've got to pay attention to the distinctions in the laws of the states in which you practice.
Yeah, I mean, we all know that there's no device, there's no methodology, there's no per se limit that you can prove someone is high or under the influence of cannabis right now. So that puts everybody at a disadvantage, both on the legal side and the employment side. So how do you make that distinction? And as Bill alluded to, it comes down to the specimen method that you're choosing. It comes down to maybe even recognizing signs and symptoms as it relates to that situation.
Correct.
That we'll elaborate a little bit more. But Bill, a question came in on does this apply to DOT drug tests as well? And I want to make sure that we make it very, very clear that federal laws are going to always supersede state law. So for federal drug testing programs, there's absolutely zero excuse if someone tests positive for marijuana, that they can use to overturn that federally regulated drug test, whether it's authorized for adult use, whether it's authorized for medical use or for cannabidiol. None of those will overturn a positive drug test result at the federal level. And even the DOT even has on their website the letters that confirm that stance, that they can't use it as as an excuse to overturn a federally regulated drug test. As we know, cannabis is still a Schedule 1 drug, illegal under federal law. Thus, it's still a prohibited substance in all those instances. Where it's different is for all your non-regulated employees, and that's mainly what we're talking about today.
Well, and it's important for people to realize that a lot of times a trucking company thinks of themselves as a regulated employer. Yeah, that's true, but you also have non-regulated workers. I've never met a trucking company that didn't have some 1, 2, 3, 20 non-regulated workers. And so as a result, you have to pay attention to and have your DOT policy, but you also need to have a separate non-regulated employee policy as well.
That's right. Please don't be applying your federal workplace drug testing policy to your non-regulated employees. You'll be calling our litigation support hotline, and we'll be trying to help you out on that side, which we don't want. We want to get ahead of this, right?
One of the first cases I ever won related to a non-regulated person who tested positive under a federally regulated policy, and it didn't apply at all.
Makes for a very quick court case, I'll tell you that right
Well,
now.
it was kind of funny because this person fell down and broke her hip. She was an accountant in the office. Obviously, DOT rules didn't apply to her, but they used the DOT policy to test her. So one of the first questions I asked the safety director in a deposition was, when she fell down those stairs and broke her hip, what vehicle was she operating? Silence.
Case
Why?
dismissed.
Because it didn't apply.
Yeah.
She went back to work the next week.
Yeah. So, elaborating on the law, Bill, we talk about statutes, regulations, court decisions, but can you kind of paint the picture of how they all work together?
It's just absolutely vital that you develop your policy and procedure based on not just statutes and the statutory language, but you incorporate the regulations and the interpretations of the agencies involved in interpreting state statutes. And you incorporate the latest court decisions and how they interpret the language of the statute, because all of that together is what we mean by the law of a state.
Yeah.
And we're going to show you some examples of how it differs here in a few minutes, but there's a tremendous difference. And if your policy and procedures don't reflect all of those things, then you're open to a possible lawsuit. And
Yeah, it's one thing if you go look at the state drug testing statute, you take that and you start writing your policy. But if you didn't look at the state regulations as they are interpreted by state legislators and how that program was implemented, you're missing some additional details. Then, Bill, we do have a couple of state examples. We'll start with Minnesota, where, of course, this is a state where a policy has specific requirements for whether it's policy for the contents of your policy and written notice requirements. Do you want to touch on this real quick?
Yeah, if you're operating in Minnesota or some of the other states that require that you have a written policy, you've got to look at the detail that those states mandate. And for example, the content of a policy in Minnesota has to include the employees or job applicants subject to testing. You've got to describe who they are. Or who the employees are that will be subject to testing. And then you have to tell them when they're going to be tested, the circumstances under which testing will be required or requested, as they say in Minnesota, the rights of an employee or job applicant to refuse. That language has to be specifically stated in your company's written policy. You got to describe any discipline or other adverse personnel action that might be imposed. You also have to remember in Minnesota, by the way, that for discipline, you got to remember that under state law, you can't terminate somebody the first time they test positive.
Yeah.
You also have to include the right of an employer job applicant to explain a positive result. Now, this is above and beyond the MRO process, okay? So there has to be some sort of a appeal procedure that you have to lay out there.
Yeah.
Obviously, also in some states, like in Minnesota, there are notice requirements. An employer has to have a written notice of its drug and alcohol policy and post it. You got to post it in Minnesota. So that's why we always talk in terms of policy and procedures, because obviously, the procedure requiring you to post notice of your program is different than a policy statement. So there are two things you got to consider hand in hand there.
Yeah. And then the next state we'll look at is Oklahoma. And this is very, very similar. It's another state that has a very detailed mandatory drug testing law for employers conducting workplace drug testing. And very similarly, Bill, it requires a employer to have a policy, have a statement of the policy, who it applies to, what circumstances testing will be done, what substances will be tested, what method you're using, what are the consequences for refusing or for failing a drug test, what actions are going to be taken on a positive. Again, the ability to explain the results, confidentiality requirements, proper appeal procedures, and down a little bit lower there, you talk about notice. If you're going to change or update your policy, there's a 10-day notice requirement, has to be hand delivered or a paper copy. So there's these specifics that are in there that they're gotchas, but if you look at the details, that's your blueprint for how you need to run your address your policy and how you implement and conduct your procedures for the enforcement of that policy.
There's also another big gotcha in Oklahoma. Oklahoma is one of three states where you can only use a test facility that has registered with the state and paid a fee. Okay, and that has been the subject of a multi-million-dollar loss for an employer. So you got to be careful. Maryland, Oklahoma, and Oregon require test facilities to be registered with the state and pay a fee.
Yeah. So again, we highly encourage everybody to take a look at the laws as it relates to the states and municipalities, the mandatory laws that are in the states and cities that you conduct business in. So shifting now, Bill, to voluntary opportunities, your favorite topic, because this is really where the ROI is that
This is
employers
where
can
the money is.
recognize on their drug testing programs, right?
This is
So
where the money is, folks.
so voluntary laws are again they're voluntary for employers to follow, but typically offer some kind of program, incentive, or benefit for employers that voluntarily follow the rules. And what we're talking about is four major things here. One is utilizing your workplace drug screening program to get a discount on your insurance rates for your workers' comp premiums. You could also use, in a lot of states, which we'll cover here, you can use a positive drug or alcohol test to defeat a workers' comp claim.
That's where the money is.
We're talking about that. There's also states that offer positive drug tests to deny unemployment claims. That is not an automatic defense. You must follow the rules in those states. And there's also states that provide employers a free immunity from lawsuits, from ever being sued for their drug and alcohol testing program. So, of course, they have to follow the rules that exist there. But, Bill, let's start with the insurance discount programs.
Yeah, in these 12 states, you're entitled to, by statute, a discount on your work comp premiums if you put a drug testing program in place that follows the rules. You can see they were very popular in the middle part of the country, Ohio, Kentucky, West Virginia, Tennessee, and so forth. I had the privilege of being involved in writing the regulations in Ohio and Tennessee. And I can tell you that we based a lot of it off of federal test procedures, not necessarily federal requirements, but just the procedures, the collection, the lab, medical review, and so forth. But some of these states have very, very detailed rules about what you must do in order to be entitled to that discount. The discounts usually range in the 5% per year range. Some go as high as 7 and 15%, but most of them are around 5% discounts.
Yeah, you're absolutely right. I'm glad you covered that, Bill, because depending on how much you pay for your work comp insurance premiums, saving 5, 10, 12% is a good little ROI just by itself, right? And as you mentioned, Bill, some of these states' laws, in order to comply, are super simple. They're mirroring DOT drug testing regulations, but some states have very specific rules that you need to make sure you follow.
Yeah, so you have to balance what your needs are. For instance, in Arkansas, you've got to follow federal rules in
Right.
terms of testing. All right, maybe you want to do some other sort of test method that the federal rules don't permit. So you have to balance what your goals are in order to decide whether to follow these rules.
Yeah. What about utilizing a positive drug or alcohol test in a work comp claim defense?
You're talking my language now, folks. I'll tell you what, if you're not taking advantage of these states' rules, you're just leaving cash on the table. This is where the money is. And these 21 states offer what's known as a rebuttable presumption of intoxication defense to a workers' comp claim. Every state in the country since 1913, think about it, 1913, when work comp first began, every state has an intoxication defense. Typically, under that defense, you have to be able to show that the employee was intoxicated at the time of injury and that the intoxication caused the injury. Those are two difficult things to prove. Well, in the 1980s, the late 1980s, when drug testing came along, state legislators began to realize, hey, we've got a tool here we can use to defeat work comp claims for employers. Okay, so they created these rebuttable presumptions. And so instead of having to prove intoxication and cause, it's now going to be presumed the employee was intoxicated or caused the injury based on a positive drug test. The employee can try to rebut that, but in some states like Illinois, where I'm sitting here in Chicago, the employee's got to be able to show that something other than his intoxication was the sole cause of the injury. That's a tough thing to do.
Yeah.
So my point is, this is where the cash is. Nick and I have a customer who's in all 50 states, and they heard us talking about this concept. And so they asked us to set up a pilot project for them in 6 states, just 6 states, okay? They wanted to see if this thing worked. In 12 months, they reduced claims by 20% and saved $6.5 million. 6 states. Well, they're now operating that program in all states.
And I guarantee you they weren't spending more than $6 million on our drug testing program, Bill. Yeah.
Yeah, exactly right. So this is one great way to be able to show that drug testing is worth the effort.
Now, obviously, that was a very large employer existing in all 50 states. Even at a smaller level, if you look at the average work comp claim being somewhere around $44,000, that's a pretty significant expense, especially if you have a work comp problem. So, if you want to be the hero for those DERs out there, risk specialists, safety specialists out there, if you want to be the hero for your company that is dealing with work comp claims, etc., this is your meal ticket to show them where you can utilize your drug testing program to save your company a bunch of money potentially. If Zoom had a make it rain emoji, I'd be raining dollar bills right now.
Let me also say that the rules are different in all these states, okay? And they're not all. Some of them just say the employee will be denied compensation, but medical benefits have to be paid. Some say that both medical and compensation are paid, and that sort of thing. So are denied. So you got to be careful. Now, the shaded areas, New York, Wisconsin, New Mexico, Alaska, those, as long as you can demonstrate you did a drug test properly, though, you'll get a credit. So just you've got to look to see how the rules differ state by state there.
Yeah. If there's anything you take from today's conversation,
take advantage of this, please.
This is your opportunity right here. Yeah. And then shifting outside of rebuttable presumption, there's also industry-specific laws or required state laws. Some specific industries, which are typically safety-sensitive, healthcare workers, childcare workers, shuttle, taxi bus drivers, school bus drivers, and Bill's favorite, bungee jump operators.
North Carolina.
Carnival operators, some other fun stuff like that, have specific requirements for those specific industries that you must follow if you are conducting business under those required industries.
Exactly. So
then I mentioned immunity laws. You want to cover that, Bill?
Yeah, there are a number of states, Alaska, Arizona, even Iowa, in its drug testing statute, offer or provide for employer immunity. So that if you did testing properly, according to the state's rules, then you're going to be immune from a lawsuit. Now, the courts in Iowa have said that if you didn't follow the state statute, then you don't get the immunity. kind of makes sense. Okay.
Yeah.
And then finally, there are maybe a handful of open states, meaning states that don't have any rules whatsoever.
Yeah, in that situation, of course, you're going to look to industry best practices for conducting your workplace drug testing program, policy, methodologies, and discipline, all the rest of that. So,
Yep.
okay, so that's the coverage of the laws. So how do you piece this together? What strategies and guidance can we provide for putting it together in both your policy and then, of course, we're going to cover next after this your procedural documents. So, we talk about this all the time. Customers come to us and say, "Hey, we need to get a drug testing policy in place." If you're conducting workplace drug and alcohol testing today and you don't have a policy, you are a litigation target. I'm just going to be that plain and simple. If you have a zero tolerance, coast to coast, nationwide zero tolerance policy, you are a litigation target. The rules and regulations that apply here have differed and have changed so dramatically that is impossible to have a coast to coast zero tolerance drug testing policy. You have to consider state specific rules in your policy. So, Bill, do you want to talk about the strategy that we've kind of adopted or promote?
Yeah, because the rules are so different in every single state. And let me also make one point. Even though the state statutes might not say you must have a written drug testing policy, it's going to be vital when it comes to defending unemployment claims, work comp claims. One of the first things you'll find is that the courts are looking to see if you had a written policy. Okay. So even though a state statute on drug testing might say you got to have a written policy and that's got to have one, two, three, four, five things in it, please understand that it's going to be critical in unemployment cases and work comp cases. So the way we approach things and helping multi-state employers deal with this, or employers with both regulated and non-regulated workers, is we start with a core company policy. In other words, let's assume there are no rules that apply to you. Okay, how do you want to test? Who do you want to test? When do you want to test? Just throw in the kitchen sink, if you will. Okay, we'll put that together for you, but then we will add addenda, be it a DOT addenda or a state of Minnesota addenda or Oklahoma, as you need. Okay, so that the people in Oklahoma don't have to be worried about what the folks in Minnesota have to deal with. You see, it's just a heck of a lot easier, especially with the state intranets or company intranets these days. It's just so much easier to distribute what the rules are if you approach it as a core plus addenda approach.
Yeah. We certainly recommend the use of acknowledgement consents forms for all your non-regulated employees. Of course, that's shunned upon for federally regulated, as testing is implied. The use of internal checklists when you're implementing a program or going about for reasonable suspicion or post-accident situations, and certainly promote education and training your staff on the dangers of drug and alcohol, the details of your substance abuse policy, and training them on how to recognize the signs and symptoms of workplace substance use, which again we'll cover here a little bit briefly. But as Bill mentioned, when you're going to draft your policy, it's incredibly critical to specify the why. Why are you conducting drug testing? What's your philosophy? Addressing the who your testing program applies to, whether it's safety sensitive employees only, whether it's employees only versus applicants, defining that, right? What prohibitions are there? What substance will be tested? Where testing is expected to take place? When and what reasons it's going to be taking place? And then, of course, what methodologies or you're going to be using to conduct drug testing? And then, most importantly, what consequences will be imposed for those that violate your drug testing policy? Whether you offer them a second chance agreement, whether they offer them reassignment, or whether they're automatically terminated. Those are all things that you're going to need to consider. And just divulging a little bit more here from a statement of the policy, it's really about, workplace safety, but do you also need to consider client or contract driven issues if you're a federal grant, federal operators? Is there collective bargaining agreements? What else needs to be considered, right? Again, who the testing applies to, whether you're doing it just for pre-hire or you have a comprehensive post-hire program, which we certainly promote and encourage. Addressing the rules separately, as Bill mentioned, for your DOT regulated employees and your non-DOT employees, and maybe even your contractors. It's important to delineate there. If there's notice required, how is that being distributed, or how is the policy being posted? What drugs you're going to include in your drug testing panel, or what would be prohibited? When testing takes place, we certainly encourage employers to test pre-hire today, regardless of the topic of marijuana, and certainly encourage strong, comprehensive post-hire testing as well. Collections and lab confirmations, how's that going to be handled? What's the process for disputing a drug test result? How are you going to handle a dilute drug test result? How are you going to handle shy bladder situations, exception handling? If you're going to offer your employees an avenue for
Before you,
treatment.
hey, Nick, before you move on past that dilute issue, what was Quest's latest number on attempts at adulteration?
Yeah, their show with urine
100?
drug testing was like 633% of the time an increase in those that tried to cheat their urine drug test in one shape or form.
Yeah, marijuana use has increased so much that the attempt to dilute specimens has dramatically increased. So keep that in mind as you go through that. Sorry.
Yeah, and also addressing things, discipline. What's going to happen when someone violates your policy? What options are you looking at there? And again, we're certainly proponents of second chance agreements or reassignment where available, versus just terminating somebody blindly. But again, that may depend on the specifics of your workplace, right? Notice of rights, employee education, supervisor training, and most importantly, also who to contact in regards to questions of the policy. So these are all the things you're going to need to consider when you go to either draft your policy fresh or go to update it. Also, things to consider, as we talked about this before, I'll drive it home one more time, but what states, what municipalities do you operate in? Do you conduct business in, especially for those multi-state employers and employers with remote workforces? And then, of course, what the nature of those states are, whether there's mandatory or voluntary laws, whether there's any case law that dictates how you can conduct your drug testing program. All of these things here need to be considered. A drug testing policy doesn't need to be 50 pages long. In fact, if you have a 50-page drug testing policy, nobody's going to read it. It's going to be tough to apply. So keep it simple as much as you possibly can while you incorporate some of these things. And then the last thing I'll mention here is some emerging technologies and solutions. As we talked about the evolution of marijuana laws and limitations on employers, we certainly see a trend of employers looking at oral fluid drug testing with the many benefits that come from it, but primarily because it's a methodology that can detect delta 9 THC and no other cannabis metabolites, complying with those state and municipal laws that limit employers. Also, there's the evolution of proctored drug testing collections. There's also the evolution of cognitive or fit for duty tech apps that are out there as technology comes in to try to solve some of our problems with establishing reasonable suspicion, etc. So just stay abreast of those different changes and the new products that are out there and how you can keep your program in flux with the different changes in the evolution of workplace drug testing. All right. So we're going to wrap with some procedures, and then we're going to talk about job descriptions. Lastly, we'll get to our Q&A. So you can write the best policy ever. You could have Bill Judge write it. It's the greatest policy ever. But if you don't have procedures related internally, then you just have a piece of paper, quite frankly. Right, Bill?
Yeah, well, exactly right. I mean, the problem you have is that some of these state statutes and regulations and court decisions are so detailed, like Minnesota, Oklahoma, North Carolina, Iowa, that there are certain things you want in your policy, but a lot of stuff is subject to procedural issues, meaning telling you, the person operating your program, what you need to do. And so you have to make sure you're staying abreast of the procedural changes as well.
Yeah. Like you mentioned earlier, if there's a notice requirement in your state, you're not going to put that in your policy saying that you as the employer must make notification, but you better have that being an internal procedure to make sure that notice goes out so that you're not in violation of the state law. So there's
as you'll see in a second, North Carolina has 2 notice requirements. So
that's right.
Yeah, you got to pay attention to these rules. Here's my favorite guy here, my little friend, the cat.
The wet cat.
Yeah, the wet cat that just
Yeah.
wants somebody to tell them what to do. And by God, we get a call like this just about every day. It's like,
And we
oh
get
my
a lot of
God,
wet cats on the line asking us just here's what happened, tell me what to do. But
please tell.
procedural things again, or how you distribute your policy, what limitations might exist, what acknowledgments you're going to require, how you make notification, where you post the policy, when testing is going to occur, maybe you have what lab you're going to be using or what collection sites you use. Internally, how to follow up on a refusal to test or advert or exception handling. Those are the type of things you're going to need to have documented procedural wise that complement the rules within your policy.
Yeah,
Now,
and,
Bill,
and let
we
me
talked a
mention
lot
too.
about, go
Yeah,
ahead, I'm
I know
sorry.
we're I know we're short on time, but let me mention to you there are 14 states that require you to use an MRO. If you don't know what an MRO is, call us. We'll tell you.
Yeah.
Because I believe if you don't have a test result from an MRO, you don't have a test result.
Yeah.
Period. Okay.
And putting together, like we talked about statutes, regulations, policies, and procedures, and how it's important that they all play together as the law for your drug testing program to be compliant and defensible. Here's a couple of examples we have for you. You want to start off with the Oklahoma example?
It's so critical because you got to look at the difference between the statute and the regulations or the court cases. So here in Oklahoma, the question is, what can you test for? Well, it describes in Oklahoma what a drug is, okay? And it says a drug means amphetamines, cannabis, cocaine, PCP, hallucinogens, on and on and on and on. But then you get to the regulations and it says, oh, but you can only test for Schedule 1, 2, or 3 drugs. All right. Well, what is that? How do you determine what those are? You better have somebody in your advisory group, your lab or whatever, that can tell you what those substances are so that you know what to test for. And they need to understand if they're testing for a test coming out of Oklahoma, that they're limited to reporting to you the Schedule 1, 2, or 3 drugs. There was a company in Oklahoma lost a lot of money, over $1 million,
Yeah.
because they tested and found a Schedule 4 drug and they acted upon it. All
If you
right,
want to
North
know if
Carolina.
you want to know what a MRO is, or if you want to know what are in schedules 1, 2, and 3, contact your local ARCpoint professional. They'll be able to help you on that.
Absolutely.
Bill, you
North
talked about,
Carolina. Oh, go
yeah, no,
ahead.
North Carolina, just briefly.
Yeah, North Carolina, the statute itself does not mention notice at all. Okay. But in the regulations, as you can see, you're required to provide notice before a test and after a test. So there are two different notices required in North Carolina, and we've got some examples of what those might state. Iowa is a final example showing you the difference between statute and court decision. The state of Iowa describes when a post-accident drug test can occur, and basically it's what's known as a Chapter 88 or typical OSHA, Iowa OSHA kind of injury or damage to property that could exceed $1,000. Okay, but then there was a case called the Skipton decision, where a woman had and suffered from carpal tunnel, and for over a year was getting treatment for carpal tunnel. A new HR director comes in and says, okay, if she's off getting treatment for carpal tunnel, she's got to get a post-accident drug test. Well, she complained. She refused, actually, and she was subject to discipline. And she got a lawyer and she sued. And the Supreme Court of the state said, "Wait a second, that's not an accident. Carpal tunnel, soft tissue injuries are not considered accidents." And Nick, if you want to read that, my eyes are too bad to be able to read that Iowa Supreme Court ruling, which is kind of funny, actually.
Yeah, it just says that it's defined accident as a sudden event or change occurring without intent or volition through carelessness, unawareness, ignorance, or a combination of causes and producing an unfortunate result.
I love that. An unfortunate result.
Yeah.
Well,
So
the unfortunate result in that case was the employer paid $40,000.
it's just important to understand that's a definition of post-accident, which can vary by state. Now, I mentioned that especially with marijuana laws, there's a lot of safety-sensitive exemptions or carve-outs that for employers that have safety-sensitive employees. And that's why the role of job descriptions has become more important than ever before. It's not just posting a job description so you can go hire somebody. Now it's defending whether or not that role is safety or security sensitive. So we certainly encourage you to take a look at it if you haven't recently. For each of the jobs that are within under your workforce, especially those jobs you're going to be classifying as safety sensitive, to prove it. describe the essential functions of that job. You can't just say that our company is a trucking company, we're all safety sensitive. You can't just say we're in a warehouse, all of our employees are safety sensitive. You have to describe the essential functions of those jobs, what they do on a daily basis that would justify them to be safety sensitive, and it's further justified under this case law that it should be written job descriptions that detail that. Okay.
Yeah, the
So
Supreme Courts, by the way, Supreme Courts of both Minnesota and Iowa have said determining what a safety sensitive is, it's not the environment, it's the job specifics.
yeah, so really just to kind of recap all of the stuff, we've thrown a lot at you today. So if you're still hanging in there with us, applause to you on that. But make sure you clearly understand the rules that apply to your program, whether at the federal level, state, or municipal level, in each of the states where you operate in. Make sure you have a drug-free workplace policy. Make sure it clearly states your company's stance and prohibitions, especially as it relates to cannabis. Make sure that policy stays up to date with the changes from regulatory or court decisions, as this is changing pretty quick. Make sure you have sound processes and procedures that complement the language of that policy that help out your managers and supervisors in the heat of the moment. Make sure you're taking a look at the different screening methodologies that are out there. This, with the evolution and adoption of oral fluid testing, is something that a lot of employers are looking at as they're trying to tackle the recent use of marijuana issue. We also huge proponents of providing your managers and supervisors with training, both on the details of your company policy that they're entrusted to enforce, but also on how to properly recognize the signs and symptoms of workplace substance use, and more importantly, what action steps to take in the heat of those moments. Make sure you have documented comprehensive job descriptions. Again, this is especially critical for employees you're going to be classifying as safety sensitive, describing the essential functions of those jobs so that you're prepared to defend yourself from the court of law, not if, but when you're ever challenged. For medical marijuana, we didn't touch on this a lot, but there are limitations and I should say protections for those that lawfully use cannabis for medical reasons. So make sure that you're not blindly declining them employment or taking adverse employment action based on a positive without first engaging in an interactive conversation with them to determine if maybe their underlying medical condition, the reason for which they were authorized to use medical cannabis, can be reasonably accommodated or not prior to taking adverse employment action. And then finally, I'll wrap to say that drug testing programs it's not a gotcha program. It shouldn't be an adverse thing. You as an employer are required to enforce and provide a drug-free workplace, safe from the impacts of impairment. So you're only doing your job to make sure you're safe, but that doesn't mean you also need to blindly terminate somebody. There's no law out there that exists that says you must terminate someone because they failed a drug test. So we are proponents of second chance agreements or reaccommodations where available. Certainly happy to talk more about that strategy. But
I'm sorry,
Ryan,
we're running out of time, but we will attempt to answer your questions following the webinar. So
Ryan, you asked for a couple of minutes. You go ahead if you want to do yours, or you want to answer some questions. What do we think we should do next here?
Yeah, I'll take it from here, Nick. Thanks so much to you both. If it's okay with you, Bill, you just suggested that you're okay with answering the questions, and we'll
Yep.
get those answers out in our post-webinar follow-up. So
Absolutely.
Kirsty and I will follow up with you both. We'll get those questions. Everyone listening in who submitted a question, keep an eye on your inbox for those answers. Nick and Bill, thank you as always for such helpful, timely information. 60 minutes goes fast, doesn't it?
It sure does.
Especially
It
when
sure
Bill starts
does.
talking about, we didn't get any lawyer jokes in, so we were doing okay there.
So, awesome information. Thank you so much. Please let Nick and Bill know what you thought about today's webinar by completing the post-webinar survey. ARCpoint Marketing on time as always. Survey link is in the chat. It will also pop up in a separate window as soon as this webinar concludes, assuming you don't have a pop-up blocker. Also, let ARCpoint know how we can make your job easier as a business leader, how we can make your business more compliant, your workers happier, healthier, safer, more productive. This is what we do at ARCpoint, and it's what we love to do. So keep the feedback rolling in. Next, if you are a credentialed HR professional, please look in the chat for your activity IDs. These will also be listed on your certificate of attendance, which will be emailed to all participants by end of day next Tuesday. As we talked about earlier, the registration for our Q2 Thrive series is now open. If you'd like to register for this legal series, you can do so by clicking on the individual links, which will be posted in the chat here shortly. And as always, as Nick mentioned earlier, if you have any follow-up questions about today's topic, you're always encouraged to reach out directly to your local ARCpoint Labs provider, especially if you have questions about our suite of employer solutions, which includes drug testing, random program management, DOT physicals, policy reviews, supervisory training. The list goes on. Check out www.arcpointlabs.com/employer-solutions to learn more, or simply click on the link for that webpage, which is now in the chat. All right, we have nearly reached the top of the hour, covered a lot of ground. Nick and Bill, any closing comments or words of wisdom?
Yeah, like I said, our hotline keeps ringing off the hook with people asking for what rules apply to them, where to find information. We certainly encourage you to work with your ARCpoint Labs expert, or as Bill mentioned, we have more stats than baseball. We keep track of this. That's all we do all day long is keep track of the changes that are out there. So we're happy to help in partnership with ARCpoint Labs. But really, it's incredibly important just to it seems administrative almost that this stuff we know there's rules and regulations for everything, but the amount of lawsuits that are happening these days, the trends of employers finding themselves in a hot spot really is growing every single day. So I can't stress it enough to make sure that you're taking into consideration everything we talked about today as you go about conducting your workplace screening program. Bill,
I
anything
would
you'd add to that?
I would just urge everybody to contact your ARCpoint professionals to get your answers. There's a lot of stuff changing very quickly. So
Yeah, you're not in this alone. We're out there. Let the nerds help you make those decisions so you can run your business.
yep.
Certainly not alone.
Yeah.
On behalf of the entire ARCpoint team, very special thank you once again to our expert presenters today, Nick Hartman and Bill Judge with Drug Screening Compliance Institute, and to everyone attending, our valued partners and loyal members of the ARCpoint network. It's an honor to serve you and to help you create compliant, safe, and healthy workplaces that thrive. We'll see you next month.
Thanks, everybody.